I am delighted to introduce our speaker, Andrew Owen. My name is Netta Sagafi. I am BHBA Co-Litigation Chair. I am here introducing Andrew Owen. He is an attorney and a colleague of mine at Hannes Shea Ravaputi. His practice focuses on litigating and trying catastrophic personal injury and wrongful death cases, including matters involving commercial vehicles, aviation incidents, dangerous conditions of property, and complex industrial and construction accidents. He has secured numerous multi-million dollar verdicts and settlements, including impressive recoveries exceeding $60 million, and is recognized by best lawyers in America for personal injury litigation for plaintiffs, and as a Southern California rising star by super lawyers. Prior to joining the firm, Mr. Owen handled complex, high-stakes litigation across state and federal courts, and he remains an active member of the Consumer Attorneys Association of Los Angeles. So now let's go ahead and get started. Thanks, Andrew.
Very good, Netta. Thank you so much. My mom would love you for that huge windup. My dad would say, enough, enough. Jeez, oh, Pete. Anyway, let's get this party started. And let me fix that. All right. Good morning, everyone. I greatly appreciate you joining me on what I think is a very, very important topic, evidence preservation. And my intention here is to walk you through how I go about preserving evidence as best I can, not only with respect to the demands that I make of the potential future defendants in my case, but also my own clients. And evidence preservation, early action really truly can make or break your case. And the reason is the trite expression, the clock is ticking with each passing day, is so very true. And the reason is a lot of the evidence that we're seeking to preserve on our cases is time sensitive, meaning the people, the companies that have this evidence, whether it's a tow yard that has a car or the lytics company that has a audio and video recording of your crash, they're under a time commitment or a time limitation to either, crush the car and sell it for scrap, or to just delete the video because our contract says, hey, we only need to keep this video for, 10 days, 30 days, whatever it may be. And so you're obligated, in my view, as a lawyer, to take as prompt action as you can once you sign a new case to, turn the screws on those deadlines that these companies or the tow yards or your future defendants that they have with respect to this evidence. And look, you're going to have cases where, it's going to be too late. That's just the reality, right? You're going to have a client who calls you 6 months later after the crash. And by that time, the insurance company for the defendant and perhaps your own client, the insurance company, got the car and they totaled it and it's gone. In those situations, there's nothing you can do. So, that we're not here to talk about what you can't do. We're talking about what you hopefully can do. So draft and send your evidence preservation letter ASAP. That is something that should be obvious. But what I want to discuss is what goes in this letter. And it doesn't need to be complex. It doesn't need to be filled with case law. I'm going to talk about the fairly recent case concerning evidence preservation that must go in your letter. But really, truly, these are the items that should go into all of your evidence preservation letters. Obviously, the claim and case identifying information. Identify the accident so you can refer to it throughout the letter in a simple way, like the subject crash, the subject collision. Legal authority, as I mentioned, we'll talk about the cases that concern preserving evidence and evidence spoliation. Obviously, identifying the specific evidence you want retained. Demand that the recipient acknowledge receipt of your letter and state their intent to either, preserve the evidence as you're demanding, or as I talk about, and you'll see, I extend the offer. I say, look, if you don't want to stow the car or save the car, I'll get it towed to, rest your case up in Irwindale. Make it easy on the defense or the defendant's insurance company, so they have no reason to push back and say, well, it's costing us, $40 a day or $100 a day to store it. And then finally, show proof that you have a basis to actually send this letter on your client's behalf, attaching your, attorney designation and supporting documentation relating to whatever you're asking to preserve. And we'll talk about that in detail. So let's go through this. Claim identifying information, pretty straightforward stuff, right? I like to put this right at the top of the letter. If you have the information, hopefully you do, with respect to the insurance company that's involved. If there's a claim number already, great. A lot of times, if you act early and you get the case early, there's not a claim number yet. But identify, data loss, who's involved, and some information about where this incident occurred. The foundational information about the crash, this is the traditional introduction into every evidence preservation letter. And really, it's something I would use if I was just sending a letter to notify a potential defendant and or their insurance company that the plaintiff or the injured party is represented. I'm their lawyer, and here's what this case is about. So identify the incident, identify at least, and this is obviously with respect to this letter, this is a car crash. Specifically identify the vehicle, whether it's a car, a helicopter, plane, motorcycle, bicycle, whatever it is. Identify that specifically. All right. Legal authority, and I'm going to go into detail specifically about this case, the Valley Union High versus Superior Court. This is the current state of evidence preservation and a lawyer, i.e., or a lawyer's obligation and your client's obligation and a party's obligation to preserve evidence, and when that obligation is actually going to be triggered. Like I said, we'll talk specifically about that case and its impact on us as lawyers and on your clients. But there's the legal authority, and you don't need to, when you're writing this letter, do a case brief on the legal authority. The point is to cite the main holding of Valley Union High, just so you're putting the recipient on notice that, hey, it's not just me as a lawyer screaming for you and demanding for you to preserve this evidence. It's actually required by law, because there's a lawsuit that is most assuredly either already filed or that is imminent. And that's, one of the holdings of Valley Union that we'll talk about. The next portion of the letter, evidence that you want retained, try to be as specific as possible. You don't need to go crazy, right? You can write broadly, but also be specific. Here with respect to this case and the letter that's on the screen now, there was obviously a BMW involved, and I use these 7 for virtually every single auto crash that I have. Specifically number 2, dash cams, video, audio recordings. It's not very often that you're going to have, just a regular passenger car that has a dash cam, but you never know, right? So you include all of these items in the chance that, maybe they do. And if they do, you certainly demanded that it be maintained, the video and audio recordings. And as you'll see later in this presentation, those video and audio recordings, tell you exactly what happened, and also tell you whether you have a case or you don't. Photographs, a lot of people who are involved in the crashes, if they're serious enough, or even if they just, cause minor damage. Cell phones are ubiquitous. People typically take photos of what happened, not with the intent of knowing that it's going to be part of a lawsuit later, but usually most people have the wherewithal to understand that, oh man, this is going to be an insurance issue, so let me document, the damage. The biggest one for me, obviously video, dash cam, if they have it, great. But most vehicles today, it varies between manufacturer and year, but most vehicles have these electronic control modules or electronic data recorders, lots of different names for the same thing. I like to refer to it, when I'm taking depositions of experts, as a vehicle's black box. And so that's why number 5 is, to me, if not the most, if there's no video and audio, but if there is none, it's the most important data because it shows speed, it shows braking, it shows acceleration, which, we all know is critical information when we're assessing a case, good and the bad. I always request, that they preserve texts and emails that they send about the collision. Oftentimes when an involved party sends texts or emails or other correspondence to their insurance company, those are privileged, and that's fine. But, I'm still going to demand all of that gets preserved. But if they're at the scene and they're texting their boyfriends or their friends, and oh my God, I just got in a crash. I was speeding. I wasn't paying attention. I was on the phone with you. Those are the types of things that I'm going to ask that they preserve because, of course, that type of communication could be very impactful. And then the last one, accident or incident reports. Obviously, you're not going to expect a private citizen to create their own accident or incident report. However, if the law enforcement responded to the scene, most likely they're going to create a traffic collision report. And oftentimes they give the face page or something related to the report to the involved parties. So I demand that they keep that. I include number 7 in the event that, there's a course and scope issue. And as part of their employment, they're using, either a company car or their own private car. And there's something about a company policy that requires them to create or fill out an accident or incident report if they've been involved while on the job. So I always include that. The next, demanding that the recipient acknowledge they've received your letter and get them to commit. Send me some type of confirmation that you're going to abide and by what I'm asking you to do. Usually when I do get a response, and I would say I probably get a confirmation less than 20% of the time. And I don't believe I have a continuing obligation to continuously remind them to preserve the evidence. I think this one letter suffices. So, that they don't respond and confirm, okay, I've put you on notice. I fulfilled my obligation to myself and to my clients and to the court. And so it's on you now that I've put you on notice to take care of what I'm demanding. And if you just sit on your hands and watch that car knowingly get scrapped, well, that's going to be a different issue. That's going to be a motion for monetary sanctions, issue sanctions, and we'll see in just a little bit potentially terminating sanctions, depending on how egregious the conduct is. In the times that I do get a response to my demand letter, it's usually, we've got the car, insurance, it's usually from an insurance company. State Farm says, hey, we will pay for whatever, 10 more days to keep it secure and safe at the tow yard. Are you able to come out and do your inspection within those 2 days? If you can, great. Otherwise, I say I'm not going to be able to do that, but at my own cost, I'll have the vehicle towed to Rest Your Case, which I'm sure a lot of you have used. It's up in Irwindale. It's a wonderful facility. It's well respected. You're not going to get pushback from the insurance company that it's an inappropriate place to take the vehicle. They're more than happy to get rid of it, so long as you pay for it. But the point is, to me, that if you actually get a response and the insurance company says, hey, we'll give you 10 days, that is less sort of like giving notice to you. So you still need to continue to be on top of your game. You still need to act. So either retain your expert to go out and do that inspection within those 10 days. One, two, call them back and say, hey, I can't do it in 10 days, but I can do it in 20 days. Maybe that won't be an issue. If it is, then you go to option three. Hey, all right, within the 10 days, I'm gonna call, rest your case, and they'll come out and get towed that vehicle from wherever it is to your to their facility in Irwindale. Of course, you're going to pay for it, but it's worth it. It's a small cost to pay for what evidence could be revealed. And then, as I mentioned, the authority to make the demand, I always include my designation of attorney. And then whatever information I have about the crash, this here, I got the face page because the police officer at the scene gave it to all of the involved parties. And so I was able to, attach it, but anything, even if it's a photograph of the business card the police officer gives with the report number on it, just something to give you more foundation for the letter and what you're asking the recipient to do. So you can say, hey, look, this is real. And here's all the information I have about the crash. And look, if you have photos, include those. A lot of times I have my own clients send me, photos, and I include everything that I have. The more information, the better, in my perspective, when you're sending out these evidence preservation letters. Okay, so let's talk about the law. And this Valley Union High case from 2023, the primary holding about, okay, when does the duty to preserve evidence begin? And it's somewhere between knowledge of the dispute and direct, specific threats of litigation. And I always include, and this is, one of the primary holdings of this case, and we'll talk about what exactly this means. But I always end it with, okay, listen, your duty to preserve evidence, it started the moment that whatever this incident was, the moment it happened. And I continue in the letter and I say, to lest there be any doubt, understand that what I'm asking you to preserve is critical evidence in either a lawsuit that I already filed or in a future lawsuit that will be filed, imminently against your insured. So that type of magic language is, to me, sufficient to satisfy this criteria about when evidence preservation begins. So before the Valley Union High case, there were two cases that dealt primarily with, when did this duty to preserve evidence begin? Is it before a lawsuit's filed? Is it after? Do we just defer to what the civil procedure statutes, provide? And so there were conflicting holdings. With respect to Cedars, this was a great case. I used to cite all the time before Valley Union, because one of the primary holdings of Cedars was, describing a misuse of discovery as destroying evidence in anticipation of a discovery request. And I would stretch this holding to argue that, look, there's no requirement that a lawsuit actually be filed or an RFP or a demand for inspection be hanging out there. You should know, insurance company and involved driver, that the second the crash occurred, and considering the nature and extent of all the damage, that you should have been anticipating a discovery request from me eventually. So this was a case I would cite all the time, and because of its perceived favorable holding. But then along came New Albertson, and New Albertson, another court of appeal case, and it was critical of Cedars, and it described that language that I liked to cite so much as dicta. And New Albertson said, look, if we're going to talk about duties to preserve evidence and when that duty will arise, we can't just create it out of whole cloth. Let's turn to the Code of Civil Procedure. to tell us when that duty arises. And of course, spoiler, there is none. There's no statutory guideline. There's no code of civil procedure that says the duty to preserve that smashed up car started on this day. It's just not in there. It doesn't exist. And so there was always this conflict between New Albertsons and Cedars. And so, there was and you compare the two together. Cedars, there's the duty to preserve evidence. There's a pre-lawsuit risk that you could be, spoliating evidence, even though there's no lawsuit filed or pending discovery request. And New Albertson that said, no, you have to have a statute that tells us how to handle this, and there weren't any. Okay, so then Valley Union comes in, another appellate court case. So you have three appellate court cases, so which one is precedential? None of them have been expressly overruled, or Cedars and New Albertson haven't been expressly overruled by Valley Union. Maybe someday the California Supreme Court will take up evidence preservation, probably not, but here comes Valley Union. And it was a very sad case. This minor student who was undisputed, required a constant adult supervision, had some issues and was known to wander, and every teacher and the principal, everyone knew that this boy needed constant supervision. Well, of course, someone dropped the ball and he wandered, and then he was sexually assaulted by another student. A security camera near the scene recorded the assault, and it was learned through discovery that the assistant principal and the security guard actually watched the video and confirmed the assault, but the video was erased. They didn't preserve the video. It was automatically overwritten. I can't remember what and I think it was probably 2 weeks, maybe it was 10 days, but it was overwritten in the normal course of however they maintain these video recordings. In other words, it was not intentional. No one, not the assistant principal, not the security guard, went in there and went delete. In the case, I believe what the testimony was, it was one of those things where the assistant principal said, I thought the security guard did it, or was going to keep the video, and the security guard started, I thought the assistant principal was going to. So it was, two fingers pointing at each other. Obviously, it's not an excuse for them not to preserve this video when they knew it, recorded critical evidence in this case. But what the Court of Appeal found was that the deletion was not intentional. The assistant principal, the security guard, they didn't go in there and affirmatively delete it. They just didn't preserve it. And that was, an important factor in this decision. The plaintiff at the trial court sought monetary and terminating sanctions, and the trial court granted them. And so that's why the school district sought a writ and got this, and it did get some relief. So the issue in this case is, when does the duty to preserve evidence arise? And of course, wildly vague, reasonably anticipated. That's when you see the duty. Okay, well, please tell me, what does that mean? What does reasonably anticipated mean? So I, as a lawyer, know what to, how to counsel and advise my client. And also, when I'm sending these letters, how I can put this information in a letter and know that I'm in a reasonable position. All right. So litigation is reasonably anticipated when it's probable or likely to arise from a dispute or incident. Something more than just the mere existence of a potential claim. And also reasonably foreseeable. That standard, it does not require that future litigation be imminent or probable without significant contingencies or even certain. Okay, that provides a little bit more clarity. I mean, so does this crash that you're dealing with as a lawyer representing your client, would this be something that would typically lead to a lawsuit? Well, sure. I mean, because they hired you. So it's easy for us as plaintiff lawyers to say, well, of course, a crash like this always results in a lawsuit. But that's just frankly, it's not the case. And so you have to look at it using these four factors. Okay. So that's one of the helpful things about the Valley Union case. It starts pretty broad, reasonably anticipated, gives some more confines to what that means. And then the court finally said, okay, look, use these four factors when you're considering whether the duty to preserve evidence has sprung, right? So the type of injury or severity, how often similar kinds of incidents lead to litigation, course of conduct between the parties, whether the parties have been involved in litigation in the past. I interpret number 3 to also include, in terms of the course of conduct between the parties, me, on behalf of my client, sending an evidence preservation letter to the insurance company or to the driver, his or herself. So that's what I think satisfies number 3. And then number 4, what steps did the parties take after the accident and before the loss of evidence, including whether the defendant initiated an investigation into the accident themselves. So this is some helpful guidance, and to Valley Union's credit, they also gave some specific examples. Slip and fall and prison incidents predictably result in litigation. I mean, if it were me, and it is me, I'm a plaintiff's lawyer, I would say, well, look, if a slip and fall incident predictably results in litigation, so too does a serious car crash that results in, property damage that results in, potentially paramedics being called to the scene and your client being taken to urgent care or the emergency room for care. But that alone is not enough. Okay. It must be combined with other circumstances, and the other circumstances, I'll just go back to the 4 factors. Okay. Because I equate like the slip and fall and the prison incidents to fall under that factor number 1. I also think it falls into factor number 2. But I think, to me, what the Valley Union is emphasizing, it's got to be, okay, it's not just the accident itself. You have to have more information in order for this duty to arise. They distinguished, understandably, because it was a school district case. They said they used school district cases in general because of their heightened duty. The reporting of a student-on-student sexual assault alone, without any of the other factors, that alone weighs heavily in favor of finding that it was reasonably foreseeable litigation was going to commence. And so, as a result, the duty to preserve evidence sprung then. Okay, so what happened was, in Valley Union, the Court of Appeal, it affirmed the trial court's finding that the school breached the duty to preserve, but it found the terminating sanction, because I think my memory is the court struck the school district's answer. And the Court of Appeal found that that was too much because the destruction was not on purpose. It was not willful. So it remanded it to the trial court to consider for, other alternatives. Now, you draft your evidence preservation letter, you're good to go. So what do you do now? You send it in some way that you can show, if you need to later, if you're going to file a motion for, monetary issue and or terminating sanctions, show proof, affirmative proof that you sent it and that they received it, and that creates a verifiable record of service. So that's not one of those, I never got it. If you send it by regular US mail, I wouldn't be comfortable going back to my law school days saying the mailbox rule, Your Honor. I think you'd get some eye rolls, considering the infinite number of ways that you could send an evidence preservation at a reasonably cheap price, including for free, by email, considering the ubiquity of emails. So, So create a verifiable way to record service. And so as we talked about who gets it, I'm telling you, everyone, just like Oprah giving away cars that one time to her studio, I'm sending this evidence preservation letter to anyone identified in, the traffic collision report, in any document, um, the insurance company, and this is who I'm talking about. Of course, the driver, and I have no reservations, even though ultimately, if I haven't already filed a lawsuit against the driver that I'm going to, I have no reservations of directly communicating with the driver, because typically at this point in time, when I'm sending the evidence preservation letter, the driver's not represented. And so, and I'm not sending any correspondence that's unethical. I'm not extorting any future defendant. It's entirely proper to send evidence preservation letters to unrepresented parties. Obviously, if you know a party is represented, when you want to send your evidence preservation letter, you send it to their counsel and not to the driver directly. But in situations where you know that they are not, send it directly to that driver. Also, the registered owner. You put that registered owner on notice in the event it's someone else than the driver. A lot of times you'll learn from the face page of the traffic collision report, or maybe your client overhears something, or the driver of the other vehicle tells your client at the scene and causes you to see that this might be a course and scope issue, that there might be an employer who needs to get my evidence preservation letter. And the tip off is usually when the face page of the traffic collision report, the registered owner, is whatever, Viacom or a company. And so when you see that, my reaction is usually two things. One, commercial policy. Two, that company is getting my evidence preservation as well. And next, the tow yards. If the collision is often serious enough, the vehicles would be towed. These tow yards will only keep it for as long as they're continuing to be paid by the insurance company. They have the least regard, in my experience, of your evidence preservation letters. And the reason is, you can't separately sue a person or a company for destroying evidence, not a separate tort. It's usually, it comes up in motions for sanctions, monetary issue, or terminating sanctions against a party. But I still, send it to the tow yard. And I always follow up to the tow yard once I send it, because I want to know what their clock is. And usually they tell me. I have pretty good success when I send a letter to tow yard. I say, hey, how long are you going to be keeping it at your tow yard? And they'll say, oh, well, at State Farm, it'll be 30 days or 10 more days or whatever it is, or it's indefinite. I've had criminal cases where law enforcement puts a hold on it because it's evidence. And in those situations, okay, fine, that car's not going anywhere because the criminal case will subsume your civil case, at least for the time being. Insurance companies, obviously, the insurance company that's identified on the traffic collision report, or in an exchange of information between your client and the other involved party at the scene. And then I also, depending on, where this crash occurred, I do try to myself, I go Google Maps, Google Street View, see where it happened. Again, we talk about ubiquity of cell phones and emails, security cameras, ring cameras, external cameras. They're almost all over the place now, for good and bad. But I, do a Google Street View, see if there are businesses that may have cameras in the area that might have captured our crash, or I send out a private investigator to do that work for me. If something, my investigation or my investigators' investigation reveals stores, then I send out evidence preservation letters to those stores. And then equally as important, you have to send your evidence preservation, not a letter. I'll talk about what to send, but you got to put them on notice too immediately. And the reason is, as much as we like to send these letters out to the future defendants or the actual defendants, that duty arises. It's not a one-way street. It goes both ways. And Victor Valley emphasized that duty, and it said when a party, okay, so it's not just the defendant, it's your plaintiff. They have a vehicle that was likely involved in the crash. That vehicle is evidence. That EDR on their vehicle is evidence. That dash cam, et cetera, et cetera. So, if your client is represented, your knowledge will be imputed on them. So let's say they retain you, all right, and you learn, oh, your car, Miss Plaintiff, is at the tow yard. Okay, I'll handle it, Miss Plaintiff. Don't worry about it. And you don't contact the tow yard and notify them that it's evidence and needs to be preserved, and it gets destroyed, 2 weeks later. That could be, very bad for your case, very bad for your client. So it's very important that you act quickly, not only with respect to sending it out, but notifying your client and taking action on your client's behalf to protect them and to protect you and your case. And so what I do, I don't send the letter, I call them. Of course, client communication, I mean, we can do a whole seminar and webinar on client communication, but this is one of those where you get on the phone with them, you talk them through everything that I'm talking about, right? And you talk about their obligations. You ask them what they have. Hey, what happened to your car? Where's your car? Who's your insurance company? You need to contact them. Hey, did you take any photos at the scene? Take any videos? Send me those, please. Send me the original JPEG images, everything. And then, send a follow-up written confirmation for your own edification as a lawyer and as a reminder to your client, right? This is part of representation. This is part of client communication. But just follow up with a written email that just reminds them of what you talked about and reminds them of their obligations and just confirms that you're going to take, prompt action on their behalf. Let me go back to this. I'm going to show you some examples of evidence that have been critical in cases that I've had, and focus on pictures. Okay, we talked about EDR, and I'm going to show you an example of that in a moment. But pictures are so critical. Again, the trite expression, pictures worth 1,000 words. It is. Pictures and videos, humans like the path of least resistance. They like to see things. They only listen to so much. So as clever and well-spoken as we all think that we are, it's a lot more persuasive and a lot more impactful if you get, videos and photos. And so getting back to this point, if your client and my client, if they have taken photographs either at the scene or whatever, taken photographs of something related to our case, please get the original JPEG images. Don't rely on them to text them to you. You need the original JPEG images because sometimes when they get texted, the quality gets compressed, and they're still usable, but they're not great. Sometimes when you send them by text or you embed them into the email itself, you lose the metadata that shows the date and time that the photos were taken. So, do yourself and your client a favor and just say, look, if you can't separately attach the original JPEG images to an email because of the file size, or you just don't feel comfortable doing it, send them a Dropbox link, because you really genuinely want all of the original JPEG images, because they will become the best evidence in your case, for the most part. So just one tip about the JPEG images, and the same thing with the videos. If you send it, sometimes when you send videos by text or by attachment emails, the video gets compressed and pixelated, and it just doesn't do you the good that it could do when it's something so easy and simple as sending them your client a Dropbox link. All right, so let me show you some examples of how an evidence preservation demand genuinely and materially helped my case. So this was uh, many of you have seen reports like this, and this is referred to as a crash data report. Um, and it's generated when there's a download performed of an electronic control module or electronic data recorder on a car. And as I mentioned how important this was a case where the defendant hit and killed two children in a crosswalk. She was convicted of 2 counts of murder, and she's serving 15 years to life. Civil cases continuing. But this information here, there was a wild dispute about speed of the vehicle at the time. And interestingly, but not surprisingly, there were eyewitnesses not to the crash, but to the speed of the vehicle leading up to the intersection, because where the intersection was not within the necessarily the view of some of the eyewitnesses. And so eyewitness testimony, as we all know, is not the most reliable. Everyone likes to say they saw everything and they know, but I had testimony of one eyewitness who said, oh yeah, the speed of that vehicle, probably going 30 to 35 miles per hour. Another person who was across the street, saw the same vehicle and said that vehicle was going 120 miles per hour. So eyewitness testimony is only so good. So EDR data and speed data from the black box, it's material data. It cannot be disputed. And this is one of those cases where I was able to learn that the vehicle, was traveling at these speeds, 1.5 seconds before impact, going 81 miles per hour in a 45 mile per hour zone. Okay. And to get to that speed, the driver had to accelerate or step on the gas pedal 98%, which all the experts testified in the case, that's like you floor it. I mean, sometimes you get to literally to 100%, but 98% is flooring it. And, in terms of service brake activation, that's were the brakes ever applied? And the answer was no. And so, and then it shows the speed of impact at 0.0 at 73 miles per hour. So I sent this evidence preservation letter the moment that we signed the case. And the tow yard that had it said, hey, the police have it. We're getting ready to transfer it to their secure facility. Would you like to come out and inspect it and offer accept it? Because you don't know what's going to happen, right? Not to say that it would be destroyed or intentionally destroyed later, but if you have an opportunity to access that data with an expert, you take it. And I got that quick access because I sent that evidence preservation letter, and the tow yard called me. They said, hey, we got it. We're going to send it over to the police tow yard soon, but we'd like to have access to it. And so we were able to get prompt access to it. I mean, the reality is the police got it. They did their own downloads, and they gave everyone access to it again later. My fear is sometimes, and it hasn't happened to me yet, but who knows, sometimes during the handing off of this vehicle to some other tow yard or some other person, who knows what can happen. It could get corrupted, it could break, the electronic data recorder, who knows, it could vanish. So it helped me in this situation. Here's another one. This is from a Lytix camera system, and it's a dash cam, and let me forward it to, let's go to right at a minute. Okay, so let me back up. This is a camera system on a FedEx vehicle, and you'll see the forward-facing dash cam. Let me press play. And the vehicle's coming, and the decedent pulls out from the curb, and bam. Okay, so obviously it was a fatal collision involving a FedEx truck. And just watching that video, You think, oh my goodness, well, that's not good for my client because he just pulled away from the curb and the FedEx driver didn't have a chance to react. All right. Well, I sent an evidence preservation letter to Lytix and I said, hey, I need all of the dash cam because I know the Lytix camera system has both the forward facing camera, but the simultaneous driver facing camera. Okay. And so I got this first video that we just watched in response to my demand letter to FedEx. They produced just the dash camera. And I got the video and I thought, oh man, this is going to be a tough case. Just watching that video alone, that isn't a great fact for me. But then in response to my evidence preservation letter to Lytix, I got the driver camera. And the Lytix camera system, I'll talk about more about that in just a moment. It records simultaneously and it records continuously. In other words, the moment the engine starts, it's recording. All right. And so let's go to 40 seconds. Okay. And you'll get a sense of what the driver was doing. Oh. So in his right hand, he has his phone and he's looking up, looking down, scrolling on Instagram, looking up, looking down, texting on his phone, doesn't see my client. Boom. Okay. So once I, got this video from Lytix, it was, of course, a total game changer. I mean, in a really material way, to the point where I was able to allege punitive conduct. And, I was able to sustain a summary or a defeat, a summary judgment motion or a motion for summary adjudication as to punitive damages based solely on this video. And as you can imagine, that can be very impactful when you're going into a mediation. All right. So, and I want to emphasize, the Lytix camera system and how important it is and how impactful it can be. The Lytix dash cam system, it's a preferred recording system that's used by major companies and international and national companies. It's, FedEx, Amazon, JB Hunt. My understanding is UPS is they've either started or they're going to use Lytix, but it is a camera system that not only records, as we looked at, the simultaneous recording of the driver and the dash cam, but it really records everything. It records the GPS, the actual location. It records, speed of the vehicle at any increment that you set. If you want to perform your search, it does braking. There are trucking companies who use the Lytix system to do, their logbooks. And so the Lytix system, depending on the subscription that the company gets, they use those for, virtually everything that can be meaningful to you if your client's been involved in a crash with one of these entities and companies. And the typical preservation for the Lytix dashcam system is 30 days to 1 year, and it's like, well, how helpful is that? And that's the issue, right? Is you just don't, it depends on the subscription that the company buys or licenses with Lytix. I believe the default with Lytix is, 30 days, but depending on, the contract, it could be up to 1 year. And that's why, as I emphasized in the, in the very beginning, why it's so critical to get these, these preservation letters out immediately. Because if it's 30 days, what happens is you send the evidence preservation letter, and Lytix's counsel, who I have a great relationship with, they're always very nice. They write back and say, hey, just so you know, we got your letter. It's very important to us that we preserve evidence. But the contract we have with whatever, FedEx, and I can't remember, I'm making this up. But the contract we have with FedEx, it's only for 30 days. You sent your letter, 3 months too late. And so we, Lytix, do not have access to whatever you're requesting, because as it relates to our cloud system, we are only contractually obligated to keep it for 30 days. And after that, we're sorry. Now, important point. Just because Lytix doesn't have it doesn't mean FedEx or Amazon or JB Hunt doesn't mean that they don't have it. Because what I've learned in doing in my cases against these entities is when there's a recordable event, a crash, something that requires the reporting of an accident up the chain of the corporation, that the risk management department gathers and collects all of this Lytix data, the whatever, whether it's, the driver and the dash cam, the GPS, speed, etc. They collect it and they preserve it, or at least they save it into their own unique system. And that's why, going back, that's why if you learn that it's a commercial defendant or, course and scope issue, Amazon, FedEx, JB Hunt, they get those evidence preservation letters. So they know that, hey, risk management, we just got this letter from, Susie plaintiff's lawyer. We've downloaded the crash data and the crash recordings. We need to continue to maintain it. So all hope is not lost. If for some reason, Lytix tells you that they don't have the recording anymore, but it's one of those where there are some situations, you're just going to be out of luck. Some corporate defendants have a document retention policy that can vary, from 6 months to 1 year. So if your client is coming to you a year and a day after the crash, and for whatever reason, it's not to, blame our clients for coming to us too late. And look, as lawyers, what can we do? We can't, be omniscient and learn when a client may be calling us. But you're going to run into situations where your client comes to you a year and a day too late, and you learn about the crash, you send out those evidence preservation letters, and it's all going to be for naught. I mean, usually. And that's just the way it is. But, you still have the duty, even if you get the case late and you think, well, there's no chance there's going to be anything available. Doesn't mean you don't send out the letters. You still do it because you never know. And you have an obligation. In my humble opinion, you have an obligation and a duty to your client that even though they may have come to you untimely, you should still reach out just to see what could potentially be out there. So, the bottom line is, and I hope you can take this, home with you and to your practice, you have to be diligent. You have to act quickly. I know, there's a lot that goes into just signing a client, right? Because there's a lot of us out there and a lot of, plaintiff's personal injury lawyers. And there's a lot of choices and a lot goes into signing a client. And you think, whew, I finally signed with them. My heavy lifting, at least for now, is done. But it's not. It's just started. Now, once they've affirmatively signed with you, your obligation to them is to send out those evidence preservation letters, 1, 2, and remind your client about their obligation. And 3, take whatever reasonable steps you believe you need to take in order to preserve your client's evidence, which is effectively writing that letter that you're sending to the defendants to yourself. Do you need to ensure that your client's insurance company maintains that vehicle. I've had cases, just the same situation, where a defense insurance company or the tow yard says, hey, the insured, they'll only keep it, they'll only pay for 30 days. I've had my own clients' insurance companies call me and say, Andy, we're not paying for more than 15 days. You need to take this off our hands. And I say, I'll be happy to. It's one of the costs. It's part of being a lawyer. So, take action. And it can really, early action can win, and I add here, or lose cases before discovery starts. And that, related to that, you will be rewarded in good and bad ways. And what do I mean by that? No case is perfect, right? Every case has some issue. I mean, every case. Maybe there's a unicorn or two out there, which is slam dunk liability, perfect clients, and unlimited insurance. Those are, as I said, those are unicorns. But the reality is, with evidence preservation and prompt action, you can learn, the bad facts of your case. You can get your own clients EDR data from their vehicle and think, oh man, so my client told me that, they were going 50, but it shows they're going, 85. And at least you're learning, of these bad facts early on, and it'll help you, plan your case strategy, your discovery strategy. And equally as important, tell your clients. It'll help you counsel your clients, manage their expectations, and say, hey, Susie plaintiff, I hadn't, my expert go out and inspect your car. We were able to do a download, and we've got some issues here about speed. I wanted to, go over these with you, and share my thoughts and how we move forward. So, as we talked about through this presentation, there's good and the bad, but ultimately both will help you, work up your case properly, help you counsel your client, help manage their expectations, and hopefully help you get, reasonable and fair value going into a mediation. And then if you have to try the case, it'll give you that evidence that will, hopefully help you get a great verdict that you can come on here and share with everyone else. So with that, why don't we turn to some of the questions? All right, and let's see. Okay, so one of the questions here is, we have a question from Michael Lloyd. What is the name of the company that you said you paid to move your car to? It's Rest Your Case. It's in Irwindale. If you call them, it's a family-owned company. Wonderful folks who work there, and it's like a massive footprint of property where they store all kinds of evidence: bikes, vehicles, washing machines, airplane parts. And depending on the level of protection you need, they have it. They can store it out in the open, no big deal. But if you need something safe and secure, they have that. And as I mentioned, they'll come out and pick up whatever the property is. Of course, it's going to cost you, but that's a client cost, and that's how you advise your client. That's going to be one of the case costs that they pay in the event you secure a positive result for them. But yeah, Rest Your Case in Irwindale. And then, how do you handle advising your clients to preserve his emails and texts regarding the collision? And that is such an important question, because the RFP is coming from defense, all non-privileged emails and communications and texts about the subject collision. And I do it at the same time I'm advising them of their duty to preserve the car, the bike, the photos that they have taken. And it's one of those, to me, like the emails and texts, it's one of those where you say, hey, look, don't ever, destroy these, the good or the bad. I don't care if you've sent bad texts. It's going to be an issue if you destroy them. So send send them to me. So that's in an email or first rather with a phone call, when you're doing the introduction after they've signed with you, you go through the whole spiel. And that's something that I'm big on when I first sign a client or a case gets referred to me and I'm taking it over. I always have a meeting either in person or by Zoom with a client. And I spend an inordinate amount of time with them going over all of this. But that is, something that's very important. So short answer, phone call or the Zoom meeting, however you make your introduction, and then follow up with a written confirmation. Hey, forward to me and my team all of the texts, all of the emails, everything else. Again, if you need help doing that, because some of our older clients are comfortable locating their text or email, whatever it is, I'm here to help you. We'll figure it out. But the point is, you have to get that evidence because you do not ever want hanging over your head a motion for monetary issue or terminating sanctions against your client for something that could have been avoided, because those motions are such a powerful tool to steering settlement, especially if they're hanging out there during the pendency of a mediation, or even better, if you get a favorable ruling before a mediation going into it. Last question is preservation demands in the employment law context. And Eric, I thank you for that question. I have to sort of punt on this one only because I don't practice employment law. But let me just throw it out there that I wouldn't, if it's the same type of situation where my client was harmed by, I'm sending that evidence preservation letter to everyone. Unless I know affirmatively a recipient is represented, everyone, like Oprah giving out those cards, everyone's going to get one of those letters. I'm sorry, I can't give more light or information on employment law cases, but I appreciate your question. And with that, I think that is it. So thank you everyone for coming today. I hope, this information is helpful to you. Please reach out to me. I have, my information is here. That's my cell phone number and my email. I'm always available. If you ever need anything in any type of case, pleading, discovery, oppositions, motions, call me, email me. Let's talk about your case. I'm here to help you. I'm people help me throughout my career, and we all get better when we help each other. So I thank you guys all for coming today and participating, for all your great questions.